Hello, everyone, and welcome to the Don't Risk It podcast presented by VFIS Client Risk Solutions. This program focuses on the exposures our clients frequently encounter and discusses some potential solutions to help reduce these exposures. I'm your host, Chris Rodgers with VFIS Client Risk Solutions, and today we're discussing the VFIS Employment Practices Helpline. Joining me on the program today is Wendy Melk, a partner with Jackson Lewis Law Firm. Wendy is joining us today to discuss the features of the helpline and some trends in employment practice liability. Wendy, I want to thank you for joining the program today, and I really appreciate your time.
My pleasure, and good morning, and happy holidays to everybody.
Well, thank you for that, Wendy, and like I said, we really appreciate you joining the program. So can you walk us through what the Employment Practices Helpline for VFIS clients is, and how does it work?
Sure. So the helpline is a risk management tool that Glatfelter utilizes in conjunction with Jackson Lewis. And it is essentially a 1-800 or 1-866 toll-free number that insurers can utilize to obtain general employment law advice on essentially any kind of issue in the employment law field that employers encounter. And so we provide just general employment legal information through our network of 61 offices throughout the country. And the way it actually works is that the call comes in to a central location. We ask you, the insured, to provide us with the name of your company, your name, your policy number, a little bit about the question that you have and the jurisdiction. And then we send that to the appropriate office, who will return your call and provide you with the information. The helpline, it's a 15 to 20 minute call. This is of no cost to you, the insured. On the call, we give primarily general information. So, for example, we can't tell you, can I fire Wendy? What we can say to you is, we'll get all of the background. We'll talk to you about what you've done in other situations, and we will give you advice as to how to best mitigate the risk of firing Wendy if you decide to do it. And then based on the discussion, you should have enough information so you can hopefully weigh the pros and cons of making those kinds of decisions. So the helpline is everything for those kinds of calls to, am I covered by the FMLA and what is it? Or how does the new Pregnancy Workers Fairness Act impact my business? So again, it's the full range of calls. Glatfelter will know that you've called the helpline, but they do not know what you called about or what the advice is. They do just get some information about who is utilizing the hotline. And I do just want to give a caveat that while the helpline is a fantastic risk mitigation resource, it is not a substitute for relationship with legal counsel. So while we will be giving you advice, we do suggest that if you have legal counsel, this is not a substitute. There is always the option, if you call the helpline and you need more information than a 15 or 20 minute call can provide, you can talk to the Jackson Lewis attorney that you're speaking with about, a broader relationship. But we definitely encourage you to use it. It's a fantastic risk mitigation tool. And given how explosive employment litigation is in the United States, we would certainly encourage everyone to use it.
So it sounds like there's a lot of great benefits to help as part of that process. You're not 1-800 be my law. You're part of the process to get our clients informed, to get them down that road. But like you said, it's general information. You're not a legal representative.
Correct. I mean, it's again, given that it's a 15 to 20 minute call, we don't want to do the insured a disservice by short shrifting things. And so it is not a substitute for a legal relationship, but it is an excellent place to start. And we can answer lots of different kinds of questions. So, for instance, as I said, questions about, I have an employee who has a criminal conviction in XYZ jurisdiction. What should I do about that? To, can I fire Wendy? To the statutory calls. And again, it's of no cost to the insured. So to me, it's sort of a no-brainer to use.
Yep, it never hurts to ask. So there's the only questions that are dumb are the questions that aren't asked. So that's definitely a great
I
tool.
agree with that. There's no such thing as a stupid question, right?
So why is it so important to get ahead of the curve on employment practices liability exposures? I know you mentioned that it's something that is far more prevalent in the workforce today. So can you elaborate on that a little bit?
Sure. So I'll start with a little background. When I joined Jackson Lewis 28 years ago, we had 10 offices. Fast forward 28 years, we have 61 offices. And all Jackson Lewis does is represent employers in workplace law types of issues. And the reason why I'm using that as an example is because we have seen an explosion of employment-related litigation. If you look at federal judges and what's on their docket, I think, and these are rough figures, I think probably 50% of a federal court judge's docket, the cases on his or her desk, are employment-related litigation. So there is an enormous amount of litigation. Litigation is costly. You, the insured, have to pay your retention. There are significant costs related to litigation. There's costs related to lost time and profitability by employers' witnesses having to participate in the investigation and litigation process. There's always the component of a reputational harm that can occur even when you just have a claim that's filed, it's public. And there are a lot of, publications who actually wait by the clerk's desk to look at all the filings so that they can write articles about, allegations made against employers. So it is incredibly important to protect your organization as best as you can to make sure you're staying ahead of the curve, as you say. Look, I always say to my clients, anybody can sue anybody for anything in the United States, but using the helpline and other risk mitigation tools puts you in a better defensible position, or at the very least makes you think through what the different options are and the different risks and exposures are so that you can make a decision that's best for your business. But it is, as I said, given the amount of litigation, and especially when you're looking at the metropolitan areas in the United States, the plaintiffs bar, those are the plaintiffs lawyers are very, very active. It's a very, very cohesive network. The plaintiffs lawyers in employment law throughout the country all speak with each other. They have national conferences. If somebody thinks up a theory in Texas, somebody in New York will, glom onto that theory. So, knowing what your exposures are, knowing what the pros and cons of decisions are in terms of protecting your organization is incredibly important. And that's what this risk mitigation tool can assist with.
Well, it sounds like based on I'm from Oklahoma, so my math isn't the best, but it sounds like in the last 30 years, there's been a 6-fold increase in the amount of, in these types of cases, if you have 6 times the amount of offices that you did before. So I'm guessing that you have all got to see quite a few of the claims and see what trends have developed. So can you talk about what kind of claims that you see most common in this area? Maybe the top 1, 2, or 3. In that area?
Sure. So, look, you discriminated against me because of my sex, race, national origin, name a protected category. just your garden variety type employment claims that we hear day in and day out are always at risk, which is why, asking questions and understanding potential exposures before you make those decisions is really helpful. So we see just the basic claims; those are always, coming in and out. What we're seeing in terms of trends in 24 and moving into 2025, we are seeing an uptick in claims related to pregnancy. This has been sort of a slow burn that we've been seeing over the past couple of years, but a new law went into effect this year called the Pregnancy Workers Fairness Act that imposes new obligations on employers. And there is a concern that some employers may not be cognizant of these new obligations, and B, it's a very technical law, so we do expect to see a lot more claims under the PWFA and pregnancy-related claims. So that's one area. Paid leave, right? Disability-related claims, we've always, for the past 10, 15 years, that has always been a fairly big bucket of claims, and we always expect to see, that continue. And again, that's because our mix of disability laws, right? There is the federal Americans with Disabilities Act, then there's oftentimes a state law component, and then a local law component. And it's very technical, and it's an area that a lot of employers struggle with. So that's another area where we see a lot of claims, and we do expect to see that trend continue. We are seeing an uptick in what we call reverse discrimination claims. Those are claims where somebody who is not in the minority, whether it be in race or age or gender, brings a claim and says, I was treated less favorable than somebody within those protected groups. And since the Supreme Court Harvard decision in 2023, we have seen an uptick in these kinds of reverse discrimination kinds of claims, which at the end of the day are really litigated like any other kinds of discrimination claims. But I do think that employers should be thinking about these things as they are making decisions. A couple of other areas, non-competes. Not necessarily an area where we're seeing that huge of an uptick, but we are seeing a lot more regulation. There were the FTC guidelines that were issued earlier this year that essentially would ban all non-competes. Those have been enjoined. I don't think we'll really see those come to fruition, but a lot of states have put a lot of restrictions on an employer's restriction of competition within the workforce. And then the other area where we are starting to see an uptick, and in particular the EESC is looking very closely, is with AI, artificial intelligence. And where we're seeing claims arise out of AI is when an employer is utilizing some type of AI algorithm to make decisions about hiring, to make decisions about performance, to make decisions about discharge. And so the concern when using AI is what we call a disparate impact. Are the decisions that the algorithm is making disparately impacting one protected group, for example, on the basis of age or race, over another? And one of the concerns that is out there is that employers may not know that they are using AI. And so we think it's really important that employers really, are taking a hard look at this. If they're using third parties to help them recruit or evaluate applicants or evaluate performance, you need to ask the questions of what kind of systems is that third party using, because we do expect that an employer could potentially be held liable for the decisions that this third party algorithms are being used for the employer's workforce. So those are a couple of the trends that we're keeping an eye on, and that we're seeing claims starting to uptick.
Certainly a lot of moving parts, and with all the technology that's coming on board, there's going to be more moving parts going forward, as you mentioned, with AI and whatnot.
I agree. I agree.
So one final question. Many of our clients are nonprofit, volunteer, fire, and ambulance agencies. What would you say to those leaders that feel that these types of issues don't exist in their organization, being a volunteer agency?
I think you have to really take a close look at how your organization is organized, right? So a lot of these who are using volunteers, are they really volunteers or are they employees? If they're truly volunteers, there are some exceptions, although there are some, more local laws that may provide a claim for a volunteer who feels that they have been mistreated by the organization. But really, I think the issues that nonprofits face are exactly the same as for-profits, right? They're employers, they employ employees, they use contractors, they use consultants, they use volunteers, they use interns. There are very specific rules about interns and how interns are paid, and I think that's something that all organizations need to pay attention to. But at the end of the day, these organizations have very similar kinds of exposures. There's also, to the extent there's any kind of civil service laws, if these are organizations that are, municipally related, then I think an employer really needs to be cognizant of, what kind of action can I take against an employee who may be protected by the civil service laws. Another issue, especially for, some of the employers in that space, are union-related issues and making sure that there is compliance to the extent that there's a CBA. So again, I think that employers are employers. There are different laws. So, for example, if you're a federal agency, right, or let's say a federal agency, there are certain claims, or not a federal, a government-related agency. There are certain claims that can be brought against a government agency, for instance, a 1983 kind of claim. But for the most part, it's really the same kinds of claims. You terminated my employment because of my race, color, sex, etc. You sexually harassed me. You didn't pay me properly. So these types of organizations are really like any other employer and have very, very similar kinds of exposures.
That's a great answer, and certainly we feel the same way, and we preach that to our clients when we go out, that just because you have volunteer in the name doesn't mean that that some career policies and whatnot that they don't apply to you. That you're essentially an employer and need to be treated need to treat your folks the same way.
Yeah, and I think you really need to. Again, the concern with volunteers are they truly volunteers, or are they just employees that we may not be paying?
Wendy, I wanted to ask you one follow-up question from your previous response. What about claims? Is this in any way a substitute for the claims process?
Absolutely not. So Jackson Lewis is a law firm. We are not affiliated with Glatfelter other than providing risk management services. So if you have a claim, you should report that either directly to Glatfelter or contact your broker. But Jackson Lewis is not the appropriate claims reporting vehicle.
Well, Wendy, it was a pleasure to talk with you this morning. I really thank you for your time, and we look forward to this partnership, and hopefully our clients can get a lot of great information from leveraging y'all's expertise.
Me as well. And certainly if any of your clients have any questions about the helpline, they're free to reach out to me, personally. We're here to help, and we're excited to meet them and to help them hopefully avoid employment claims, or at the very best, put themselves in the best defensible position.
Perfect. Thank you, Wendy. And I want to thank you for listening to the program and for your interest in VFIS safety resources. I want to thank our guest, Wendy Melk, once again for her time and information. Please consider subscribing to our program to stay up to date on new content releases. Also, if you like what you've heard, please consider leaving a review below. For more information about the many resources available from VFIS, please visit VFIS.com. And to submit ideas for future discussions, please reach out by emailing VFISriskcontrol@VFIS.com. Thanks, everyone, and have a great day. The views, information, or opinions expressed during this program are solely those of the individuals involved and do not necessarily represent those of Gladfelter Insurance Group, VFIS, and its employees. Additionally, all views, information, or opinions expressed are provided for informational purposes only and should not be construed as legal advice on any subject matter.